Thank you for listening to this PYA webinar recast. PYA is pleased to offer this alternative way to access our thought leadership. This is a recording of a previously delivered webinar. The information is accurate as of the date of the original event. The video recording, slides, and associated material for this and all PYA webinars are available on our website at pyapc.com. This podcast is for educational purposes only. It is not intended to be used as legal advice or an official opinion. Good morning, everyone. Welcome to the latest episode of PYA's Healthcare Regulatory Roundup webinar series. Today's topic is, Are Your Ducks in a Row? HIPAA Rule Supporting Reproductive Privacy, New Anti-Discrimination Requirements. PYA is happy to present today's webinar on these important topics. With that, I would like to introduce our presenters, Martie Ross and Karin Anderson.
Thanks, Trevor. Good morning, everyone. Thank you for joining us. If you are a frequent listener of Healthcare Regulatory Roundup, you know that we most frequently discuss regulations promulgated by the Centers for Medicare and Medicaid Services, generally around their payment models for the Medicare program. But there are other agencies within the Department of Health and Human Services that directly impact providers' operations. And today we are going to discuss three rules recently published by the Office of Civil Rights, or OCR, spending some time delving into the HIPAA rule supporting reproductive privacy, given that its effective date, it's compliance date, right, Karin? We already had the effective date, but we're looking at the compliance date of December 23rd. Merry Christmas. And then also focusing on Section 1557 of the Affordable Care Act, the final rule published by OCR earlier this year, as well as another rule under Section 504 of the Rehab Act that OCR published. So with that, Karin, take us away into the land of HIPAA.
Okay, here we go. All right, so we have a new HIPAA rule, as if we needed one more. So this is, as Martie said, this, and I'm just reminding us a little bit of history. We won't spend a long time on this. We're going to get into the meat of it. But as you may recall, we had a U.S. Supreme Court case change the constitutional right to termination of pregnancies or abortion services in 2022. So immediately after, lots of things happened, right? One was that a lot of state laws triggered up because the states now had authority over when abortions could occur. And so, and also the president issued an executive order in response to this. Because there really was a lot of public outcry about, I don't know what to comply with. I don't know how to comply with my state laws. Investigations were already happening because a lot of the state laws were criminal. So the president said, we're going to strengthen the protections of this sensitive information, reproductive health care services, and we're going to bolster patient-provider confidentiality. And I always just draw back to one of the purposes, if you remember, is that access to care. So if people don't trust that their information is private, this is sort of long researched. If they don't trust that their information is private at an institution or an organization, they won't go there. They won't seek health care, and they'll either let things fester or figure out things on their own. And so we don't want that, right? We want people to trust their healthcare providers and their organizations. So that ended up, President gives us executive order, and the HIPAA rule is changed. It was effective June 26, 2024. Not to panic if you haven't done anything about it, because it is not, the compliance deadline is December 23rd, as Martie said, 2024. Most of the things, procedures, policies need to be changed by that date. And then there's a later date for your notice of privacy practices. But just in short, basically, the concept of this rule was to strengthen the privacy protections for medical records and really those seeking reproductive health care services and providing reproductive health care services. Because again, if you just think about what was happening at the time, there were investigations of providers who were thought to against state law provided abortions, and their licenses were investigated, for example. And then patients, there were many sort of subpoenas and things sought to identify patients that were receiving this kind of care. So the one thing is let's make sure that this information is private and it's pulled, it's pulled separately, sort of as like a subset, like substance use disorder would be, to bolster patients' care and basically just better protect the community. I think that AHIMA had a quote that said, "It's shielding health information related to reproductive health care contained in medical records from law enforcement seeking to use it against a patient or provider." And that probably sums up the purpose of it the best. Okay, so when does the rule apply? So we always have HIPAA, right? All those rules apply, minimum necessary, all of that still applies. And then this reproductive health care rule applies when the care is lawful. So that's the first condition, was the care lawful? If you're being asked for information related to reproductive health care, was it lawful in the state in which it was rendered? And as we know, we don't know. We might know our state law, but we might not know another state laws. And so this rule says you'll presume that other care given in other states is lawful. So in essence, sort of start with the fact that this rule will apply for reproductive health care. It's also applicable, so that's for state laws, and it's also applicable if the reproductive health care is protected under federal law, so think EMTALA, or constitutional law. So think of the constitutional right to birth control or contraception. So those are another couple of instances when the rule would apply. Okay, so it all sort of comes down to the definition of reproductive health care, and it is broad and it is to be interpreted broadly. HHS says this should be given its sort of broadest things. The definition itself is healthcare that affects the health of an individual in all matters relating to the reproductive system and to its function and processes. So think of that as all life stages, right? So, there may be 12-year-olds that have reproductive health information. So it might be in pediatric records, all the way through your life to postmenopausal treatments, those kinds of things. So we gave examples. I won't go through all of them, but pregnancy, fertility, just different conditions that would affect the reproductive health system. But it's also not just sort of diagnosis or conditions or treatment. It's broader. It's medications, the services provided, supplies given, equipment related. So it is meant to be, and that they specifically said it's not reproductive health information, it's reproductive health care. And they've made a very big deal about how they defined it. So, and the key to understanding the definition, right, is that this is going to help you do your change your policies, procedures, those kinds of things.
Hey, Karin, I heard a presentation once that gave the example of circumcision being reproductive health care. So going all the way back to a baby and going forward, the history of reproductive health care for them.
That is a great point. And that's one of the reason I think we talk about the definition is, whereas like substance use disorder is always the comparison, like that's a sensitive set of information. It's a little bit easier to segment off because it's usually a certain type of provider in a certain perhaps type of facility, not always. Whereas this is going to be everything from your pediatrician to your OB to your primary care doctor to a hospitalization. So everybody is going to have to figure out how to flag the information. And one of the things I suspect, if you haven't already asked your EMR provider what they're doing, my understanding is they're working on flags and different ways to sort of hit that information as you're documenting it, or to help you identify that information and flag it in the record, because there's going to be just a great burden, right, on the HIM department when they get medical record requests. So the general part of the rule is, this was the purpose of the rule, right? I sort of call it this, a general prohibition. You can't disclose reproductive health care information if it's for this specific purpose. And so the two purposes are to either conduct an investigation, civil, criminal, or administrative, or to impose liability, civil, criminal, administrative, or to efforts to identify a person for those investigations or to impose liability. So those are the three things. Reproductive health care information could not be provided for those purposes. There is HHS guidance, which is helpful, that has come out, and I just wanted to note it there because it's going to deal with all the requests for information. It's talking about some of the specifics there. So I wanted to add that resource there quickly. I'm sorry. So let's jump to sort of what changes you would make from what we know already. We know there's a prohibited disclosure. We know there's this large definition. So we know our privacy policy generally needs to add this purpose-based disclosure prohibition, right? If the purpose of the use of disclosure is for a patient's health care, you know, again, the underlying HIPAA is going to apply. You know, it would be permitted for treatment. So we're trying to exchange between treaters. But if it's for this prohibited purpose, you're not going to disclose the information. The other big thing, and I think this is going to be the hardest part, and Martie, I don't know if you've had folks ask about this too, but it is the procedures. It's your internal procedures are going to completely change in so many different departments. So you've got to determine, is it reproductive health? You got to determine how to segment it off. You've now got that general prohibition, and then we're going to talk about this in a minute, the attestations, but this special group of requesters that may be conducting investigations. So they've been called out. There's extra step there. And so the training, whereas a lot of us can give, oh, sorry, I jumped ahead, where a lot of us can give just general training that really applies to all of us. We should all know it. This really has some very targeted training that you're going to have to do. The HIM department is going to be front line on this, handling requesters that they work with really every day, and it's going to completely change what they're able, how they're working with them. So as well as providers, you know, how they document, they might have to flag different things. And I also think where there'll be a heavy use of the legal department. So whereas we've gotten used to, we know how to do the medical record request, probably very rarely that you need to involve legal. I think at the beginning of this, until you see all the different kinds of requests that you're going to get, you've looked at different kinds of subpoenas and orders, I think that they're going to be heavily involved in helping you make the right determinations.
Yeah, Karin, for those of us that have been around a while, we remember the early 2000s when we were first implementing the HIPAA Privacy Rule. And probably one of the pain points was teaching these rules to law enforcement and the courts. Because they assumed, you know, we have a subpoena, we have a court order, and now you had the HIPAA rules that were beginning to impact how hospitals and other healthcare providers were disclosing information to law enforcement and investigators. And it's almost like we have to go through that again. It's going to be a retraining process. So it's not just us as healthcare providers, but it's that interaction with, you know, law enforcement and the courts.
I agree with you. And I've thought about, like, you know, probably one of the best things you could do for the HIM staff is really to give them talking points, because I think, you know, law enforcement has no reason to know probably until they're there and they're like, what do you mean you can't fill this request? You filled it 1,000 times before, and you're going to have to just sort of say this same sort of speech and educate them. We're not trying to be difficult, whatever, but the rules have changed. I mean, I think it's just going to be, and I always think about, particularly if you're in a busy hospital and you get these requesters all the time, these are usually people often you know. The court clerk calling all the time, right? The same person from the coroner's office calling all the time, you know, and sending things over. And so I think it's, you know, it's going to be awkward at best. And it's definitely going to require re-education. So that's a great point. That's a great point. And then this deadline, so those were the December 23rd. Think of having your policy and your procedures and your training done for December. This you get a little bit of a break on, although I'll tell you, we've done a couple for clients and we've helped with parts of this. And we just went ahead and did the notice of privacy practice because it made sense. Like, we'd already figured out our language and we went ahead and put it in there. But you have until February 16th, 2026. And they gave that room for that time period also because the substance use disorder changes under HIPAA also came through this year. And so both of those are due in February of the following year. So,
but Karin, when we get to February, there's not an obligation to re-provide everyone with a new notice, is there? It's just the notice you posted, the notice you give going forward needs to be the updated version. Is that
Yes,
right?
you don't have to. Yes, you don't have to go back and capture people. It'll be from that point forward. Exactly. And then, yeah, and just, same reminders, like make sure the website's updated. They'll look there. Make sure the paper copies are handy, or if you're doing iPads, just make sure it's loaded everywhere that it needs to be loaded on that day. Yeah, but you're right. You don't have to go through the patient roles. That's good. Okay, so then back to the rule just for a section. This is a little bit on the presumption that it is the reproductive health care is lawful. So we talked about this being the basis, and the reason this is important is, again, this means the reproductive health rule applies. So so you can presume that the reproductive health care provided was lawful, unless two things, and again, I'm going to call to your attention that this is probably where you're going to need some legal help, unless you have actual knowledge that the reproductive health care was not lawful under the circumstances in which it was provided, or you've received, so maybe the requester has given you some supplemental information, factual information from the person making the request, that of PHI that demonstrates a substantial factual basis that the reproductive health care was not lawful under circumstances in which it was provided. So that sounds very legalistic. And HHS goes on to say that it's going to be facts and circumstances specific. So you're really going to have to document, what you know and how you sort of made this decision. Again, the rule's always going to favor not disclosing. But if presented additional information, I think this is where you're going to have your legal counsel involved.
And the nightmare of the care was sought in a different state, and the state in which the patient resides has a different law. That is going to be, that's a phone a friend, time to call legal circumstance.
Yes, for sure. Yeah, it's hard enough to keep up with your own state law in the myriad of federal laws. Like that little web's hard enough, but much less anything else. So then, as we mentioned before, this is the other piece that they pulled out. So there's this general prohibition, but then there's this extra step for certain types of requesters. And these are the requesters they think that would most likely be conducting investigations into whether a patient sought, termination of a pregnancy, or whether a provider terminated a pregnancy. And so they are, so there's, and they have the model attestation language there as well. So you're going to see this from like we said, the coroners, judicial proceedings, law enforcement, health oversight activities. And think of that as being like, we saw very commonly physician licensure boards immediately issuing subpoenas to find out if providers were violating that. And then in essence, would be jeopardizing their license. So for those additional requesters, you'll have to have them complete and sign it. The model attestation says they are acknowledging it's not for a prohibited purpose. They're acknowledging that there are criminal liabilities if they are requesting this for a prohibited purpose. The burden on the covered entity that's receiving this is you've got to make sure it's completely filled out. You know how you get things that are half filled out all the time and you're like, okay, it's kind of okay. You cannot do that with this. You've got to make sure it's filled out to the penny, the very last sentence, because that's the burden on you, is to make sure that you got a completed one. This is again where legal would be involved. If you have knowledge that you believe the attestation is false, then you also have a duty to not, to round with legal counsel and to determine that perhaps you should not provide the disclosure. So those are the burdens on the covered entity: to get a completed one, to always get one, number one, for these people, to get a completed one, and to not have knowledge that it was false and that you just sort of went through the motions. So this is a big change, just Martie, as you referenced before, how you'll be dealing with these folks. And then, okay, the final rule. Okay, so this is on disclosure. So on disclosure to law enforcement, this is also going to be tough. And in essence, just know that where HIPAA used to say you could be permitted, right, to provide some information to law enforcement, that would be fine. No longer. they're saying disclosures to law enforcement, it's when you're required by law to provide the information. You can do it when it's required by law, and you can do it when it's not subject to this prohibition. And you've got to meet all the other requirements of HIPAA. Minimum necessary is one that they'll continually call, like, are you giving the minimum amount of information needed? So that's for disclosures to law enforcement. That's again another area where I think that you're going to have legal counsel and compliance involved. This is just an example, again, if we think about our procedures, is we're going to have to really rethink sort of authorizations, because one thing in the rule is a general patient authorization will not do. That's never going to allow you to disclose reproductive health care information. It's going to have to be a specific authorization. And then on here, I was trying to say, if you don't have the authorization and an attestation applies, then you're going sort of to this other category of the attestation, and how do we release it and what do we have to have in place? So that's, again, just another area of procedures. This is a reminder that there's criminal liability and civil liability in enforcement. So those that are knowingly requesting information or obtaining a disclosure, or those that provide the disclosure could be criminally and civilly liable. And you can be civil liability, again, back to the covered entity, if you have released the information without an attestation for those required requesters. So the criminal penalties are 1 to 10 years and fines from $50,000 to $250,000. And then also they're going to view this as a breach under HIPAA. So if you have disclosed the information, then all the breach notification requirements will come into play. So that, that's yet another sort of piece of liability that nobody wants to deal with. So then finally, these are just sort of our tips. Integral people that you probably already have on your team, but you definitely want compliance, privacy, legal, and HIM working in lockstep to overhaul the policies and the procedures. As we said, the notice of privacy practices can wait a little bit if you want to, and you can do it with your substance use disorder. That deadline's February of 2026. The business associate agreements, also take a look at those. They, you want to clarify who is handling the request in there. So a lot of business associate agreements may not require change. I look at a lot of business associate agreements. Some of them already say the business associate may never kind of respond to the individual that's making the request. They always have to forward the request to the covered entity. And we will, the covered entity will handle it and just send us your information and send us the request. So that's probably the way to go if you haven't already clarified that, so that you don't have a business associate that's made a disclosure and you don't even know about it and it didn't comply with your procedures. So I'd recommend taking a look at that as well. Let's see. These are just some resources, just so you had some quick links. The OCR briefing was actually very helpful. It's an hour, but it really goes over the purposes, why they made the changes they did. It's helpful. The fact sheet is helpful, and of course the rule is helpful. In addition to the guidance we posted earlier. And then this is the thing, Martie, of course, had to throw a hink in this. We have the presentation ready to go. And then she's like, hey, did you see this Texas lawsuit? So sure enough, September, within the last month, here we have Texas Attorney General's filed in federal district court and says that this new privacy, not only has the new rule exceeded their authority under HIPAA, but the original rule has really exceeded the authority. And so they're saying in the new rule, this obstructs our ability to ensure compliance with our own laws, right? So if we've got abortion-related laws and we're trying to get people to comply, you've now obstructed our ability to conduct investigations, get the information that we need to do that. And then also challenges the provision in the original 2000 privacy rule, as well as exceeding the authority and conflicting with government investigations, their just ability generally to conduct a government investigation. So, so these are great questions about, will there be an injunction to prevent this rule from applying. Would it apply just to Texas? Would it apply to everyone? Would it be a nationwide ban? So watch this case carefully, because Texas has tended to move very quickly. I mean, I would say, right? We've seen them be so active, and so they seem to get to the circuit court for the appeal very quickly, and so we'll see.
Hey, Karin, before we leave this topic, just as a practical matter, I mean, given how broad the definition of reproductive health care is, and given you have these 4 circumstances, these 4 types of requests, healthcare oversight, law enforcement, court orders, does it make sense as a practical matter to create a policy that you're just going to always require an attestation when you receive a request that's tied to one of those 4 purposes?
Yes, I think so. Yeah, just complete across the board, because then you're not having to evaluate each one.
Right.
I think it's a great point. Yeah.
Yeah, because it's just going to be a huge challenge to say, okay, well, here's a request on this lawsuit. Do we have to go through the entire record? And with SUD, as you said, it's relatively straightforward. You can find the relevant part of the record, but this could be, one visit. The dose of one visit may make a single reference to reproductive health care, and that would bring this within the requirements of these regulations. Just HIPAA is never easy, is it?
No.
So,
nope.
Yeah, exactly. Well, let's switch gears a bit and talk about other things that our friends at the Office of Civil Rights have been up to. And we're going to start with Section 1557 of the Affordable Care Act. And even though this law has now been around more than a decade, we are still seeing regulations that are coming out of specific provisions of the ACA. So we're going to start, as soon as I figure out where the right button is, talking about what the 1557 did. It added a new provision into the federal statutes regarding non-discrimination for those folks that participate in federal health care programs. And it is a very broad definition, so that it is going to impose these requirements on providers who participate in the Medicare and Medicaid program, but it also reaches the insurer side of the equation as well. So MA plans, Part D plans, state Medicaid agencies, MCOs, qualified health plans, all of those types of entities are going to be are currently subject to these non-discrimination requirements. The implementing regulations then for that statutory provision have been, well, it's been a back and forth, just to be honest. HHS OCR published its latest final rule in April of this year with an effective date of July 5th. The 2024 rule is effectively rewriting a rule that had been published in 2020. And the 2020 rule effectively replaced a rule that had been published in 2016. So as you see, if we have a change of administration, we have a change in the implementing regulations for the prohibition on discrimination in these federal healthcare programs. So we start Obama administration in 2016, Trump administration in 2020, now Biden administration in 2024, changing these rules. And these are revisions to 42 CFR Part 92, which is where you find these requirements with regard to discrimination. The final rule impacts both the prohibition on specified forms of discrimination, as well as the administrative requirements that are put in place to ensure organizational compliance with the non-discrimination rules. So key provisions of the final rule regarding the prohibition of discrimination begin with the definition of discrimination on the basis of sex. And in the final rule, OCR clarifies that this includes discrimination based on sex characteristics, including intersex traits, pregnancy and related conditions, sexual orientation, gender identity, and sex stereotypes. In the preamble to the final rule, OCR addresses the issue of whether this prohibition on discrimination then imposes an affirmative obligation on providers to provide gender-affirming care. And as you see here, the quote from the final rule saying that it does not create such an obligation, if the provider does not believe that care is clinically appropriate, or if that provider objects on the basis of religious freedom or conscience, if those protections do apply. That gets us to the next significant provision in the final rule, which is replacing what had been a blanket abortion and religious freedom exemption with a new religious freedom and conscience protections. So previously, under the 2020 rule, a provider could simply refuse to provide care and claim that is on the basis of a religious freedom exemption. Now, under the rule that's been in effect since July 5th, the requirement is that if you are going to make such an objection to providing this care, you must submit a letter to the Office of Civil Rights specifying the scope and basis for your claim of that exemption. And you'll read the specifications there in 42 CFR 92.3, 92.302. There's also guidance on the OCR website of the process to be followed to seek that exemption. So now, instead of just claiming at the time of service or the time of request for service that you have the exemption, instead now in advance, submitting the exemption details into OCR. Note that the effectiveness of that exemption always will date back to the date on which you submitted the exemption request, the exemption, not an exemption request, but the exemption to OCR. The third significant change made in the 2024 rule is extending non-discrimination requirements to telehealth services, as well as patient care decision support tools, more commonly known as artificial intelligence. Here is the obligation on providers as well as health plans to make reasonable efforts to identify if tools that they are using are in some way resulting in discrimination based on a prohibited factor. So we are, for example, seeing challenges to AI, that the algorithms utilized in AI for purposes of identifying certain trends tend to have a negative impact on individuals of certain races. And so the obligation now to ensure that you're not applying an AI tool that has a discriminatory effect. Well, as you would suspect, the gender identity provision in the final rule captured a great deal of conversation. And you had several folks who went to court looking for a remedy. And we have, in fact, 3 lawsuits that have at least reached the stage of a preliminary injunction. Beginning with Tennessee versus Becerra. This was a lawsuit filed in Mississippi by attorneys general from 15 states. And on July 3rd, the court issued a preliminary injunction prohibiting the effective date of specific provisions that tied to gender identity. And you see there the very specific line items that were impacted by that preliminary injunction. And this is stated as a nationwide injunction. Same day, a case in Florida, the court also issued a preliminary injunction, effectively reaching the same conclusion as the court in Tennessee versus Becerra, but in that case, it's different provisions of the regulation that are specified. It's a shorter list, and that purports only to impact providers in Florida, health plans and providers in Florida. But again, relatively narrowly, impacting the rule only with respect to those provisions on discrimination based on gender identity. The third case is Texas versus Becerra. This kind of consistent with Karin's comments about Texas federal courts in Texas. In this case, it's a challenge brought by Texas and Montana together. Again, on July 3rd, 2 days before the effective date of the rule, the court issued a preliminary injunction, but rather than limiting it to the gender identity provisions, although that was the core of the challenge in the lawsuit, the court actually issued an injunction to the whole entire rule. All provisions of the rule are enjoined in Texas and in Montana. And in fact, the court said that there was no basis provided that it could effectively carve out the gender identity provisions. So it enjoined the entire rule, leaving the 2020 rule in effect. So for example, that provision on conscious exemptions, which require the submission to OCR of a conscious exemption, that would not apply currently in Texas and Montana. Also not applicable would be several of the administrative requirements that are imposed by the rule. Now again, only in Texas and Montana have these been enjoined. The national preliminary injunction out of the lawsuit in Mississippi do not impact these administrative requirements. So for the 48 rest of us, the 48 states, these administrative requirements go into effect. These, though, have broader compliance dates than the July 5th effective date, beginning with a November 2 requirement that you designate a Section 1557 coordinator if you have 15 or more employees, and you'll see the specific responsibilities of that 1557 coordinator specified in 42 CFR 92.7. Generally speaking, this is the person that runs point on ensuring appropriate policies and procedures are in place, appropriate training has been provided, and also is responsible for any grievance procedures tied to the anti-discrimination provisions. By July 5th of 2025, covered entities are required to implement specified policies and procedures. So this is not limited to 15 or more employees. This is for all entities that are subject to these rules. These policies and procedures specifically must address language access procedures for individuals with limited English proficiency for those patients as well as their companions. In addition, these policies and procedures need to address reasonable modification procedures for individuals with disabilities. So again, we're covering that full scope of the discrimination provisions in Section 1557 and ensuring that we have appropriate policies and procedures in place. Your policies and procedures also must address civil rights grievance procedures. This does apply only to those that have 15 or more employees. Luckily, OCR, as it has been with HIPAA, is very good about publishing sample policies and procedures, and we provide there on the screen the link to the website where you can find those. By May 1st of 2025, coveted providers are required to complete training for employees on the policies and procedures. And yes, I see the contradiction as well, that you don't have to have the policies and procedures in place until July 5, but you're supposed to have the training completed by May 1. No explanation in the rule of why we put them in that order, but certainly a reason to get those policies and procedures done more and approved more rapidly than July 5 deadline so that you complete that training. Also included in these administrative requirements are notice requirements. We're not just the notice of privacy practices are changing. We also have requirements by November 2nd that you adopt a notice of non-discrimination, and by May 1st of 2025, a notice of availability of language assistance services and auxiliary aids. Let's drill down a little bit more on these notices. Starting with the notice of non-discrimination. Again, OCR has provided a sample notice that incorporates all of the required contents available at this website. The provision of the notice, again, compliance by November 2nd, must be provided on an annual basis to participants, beneficiaries, enrollees, and applicants of any federal healthcare program or activity. Remember, this rule is applicable to providers as well as to insurers, and that's why we have this language that is very, very broad. But appreciate, unlike the notice of privacy practices, which we give once, right? Karin, one time only, the requirement for an MPP, but here, this is an annual notice to be given to our patients. It also must be provided to a patient upon request. It must be posted at a conspicuous location on the provider's website, and also posted in clear and prominent physical locations, no smaller than 20-point sans serif font. Now we're getting specific, right? And where we expect individuals to be able to read or hear the notice. So we've got quite a wall now. We've got our notice of privacy practices. We have our notices under the No Surprises Act. Now we have the notice of non-discrimination, also to be posted publicly by November. Remember, it's November 2 enforcement requirement compliance date here. The notice of availability of language assistance services and auxiliary aids, so that rolls off the tongue, doesn't it? This is required compliance by May 1st of 2025. Again, also will have to be posted, so make room on the wall. But let's talk specifically about when this notice has to be provided. You have to provide the notice that the provider furnishes language assistance services and appropriate auxiliary aids and services free of charge to the patient. So we're dealing with two things here. We're dealing with limited English proficiency, so individuals that require notices be provided in a different language, as well as individuals who are hard of hearing and thus require assistance so that they can communicate effectively with the provider. The notice itself indicates that that it must be provided in English, as well as the 15 language most commonly spoken with individuals with limited English proficiency in your state or the states in which you operate, as well as alternative formats for individuals with disability who require auxiliary aids and services. Thank goodness, OCR has provided the notice in multiple languages, including in non-English letters, and those are also available on the OCR's website. The notice must be provided, again, by May 1st, the same as the notice of non-discrimination, pasting it on the website, providing it to individuals, having it posted on the walls, but also you must incorporate this notice when you provide certain electronic or written communications to your patients. Specifically, you provide the notice of availability of language assistance and auxiliary aids when you provide the notice of non-discrimination, when you provide the notice of privacy practices, when you furnish the patient with consent forms or instructions for medical procedures, when you discuss medical powers of attorneys or living wills, communications with regard to the cost or payment of care, and complaint forms. So in any instance where you have an obligation to provide these notices to a patient, in addition, at the same time, you have to provide the notice of availability of language assistance services and auxiliary aids. Again, intended to promote efficient communication between the provider and these individuals who require this additional communication support moving forward. Let's switch gears away from Section 1557 and begin talking about the Section 504 final rule, again, published by OCR in April. And specifically, let's focus on the provisions regarding accessible medical diagnostic equipment, or MDE. This is a brand new acronym for me this spring. I had never heard of medical diagnostic equipment as a specific term in the regulations, but what we have here now is a rule regarding providing this equipment in a manner to address individuals with disabilities. So again, we talk discrimination more broadly, multiple categories, types of discrimination. Here we're drilling down to the folks that have disabilities. So MDE includes equipment that's used in or in conjunction with a medical setting by a healthcare provider for diagnostic purposes. You see here the the examples provided in the rule. So it's exam tables, examination chairs, weight scales, mammography machines, and other imaging devices. Note that MDE does not include personal devices like blood glucose monitors, positioning devices like wedges, or medical or surgical implements. It's just really going to the equipment used for diagnostic purposes by a provider in a healthcare setting. The new rules regarding accessibility of MDE are derived from, again, the Affordable Care Act, which included a new Section 510 in the Rehab Act of 1973. This provision, this new 510, requires that the U.S. Access Board develop and maintain minimum technical criteria for accessible MDE. A new federal regulation of which a new federal agency of which I was not aware. The U.S. Access Board is actually a multidisciplinary board that establishes criteria and standards across several federal programs. And so it was the ADA leveraged that existing U.S. Access Board by adding Section 510 and directing the U.S. Access Board to create these standards for accessible MDE. Those standards were published in 2017. It then became a relatively long period of time for the regulations then to be promulgated, requiring providers to utilize those standards when they were created. The Access Board itself doesn't have authority to require adherence to the standards. It in fact took then the appropriate federal agency stepping in and making these requirements, applying these requirements to providers. That's done in actually two rules. Our friends, Office of Civil Rights, published their regulations on May 1st, and it applies to those same entities of which, as does Section 1557. Okay, so again, Medicare, Medicaid participating providers, plus all the health plans are subject to these rules. Separate and apart from OCR publishing those regulations, you have the Department of Justice then publishing regulations under Title II of the Americans with Disabilities Act on August 9th. And these rules apply to hospitals and clinics operated by state or local governments. Here it is kind of this tension we have between the Rehab Act and the ADA, because ADA has a very specific range of entities to which it is applicable. Title II specifically, which concerns the provision of healthcare services, only applies to hospitals and clinics that are operated by state and local governments. So DOJ publishes its rules under the ADA. OCR is publishing its rules under the Rehab Act. The good news is part of both rules is to finally bring the two rules in alignment. So now we have similar requirements applicable to that broad list under Section 504, and then the more limited list under the ADA to state operated hospitals and clinics. So whichever category you fall into, good news is now the rules are the same under the ADA and the Rehab Act. Specifically with regard to those MDE accessibility standards, OCR now requires that if you are a healthcare provider and you are acquiring MDE after July 8th of this year, that MDE must meet the accessibility standards, and there you have the citation of where you can find the standards, until you meet certain scoping requirements. So it's not all MDE you purchase after that date. It's enough MDE purchases that bring you into compliance with these scoping requirements. Specifically, at least 10% of the total number of units, but at least one unit of each type of MDE must meet the MDE standards. That standard raises to 20% if you are a provider or a program that specializes in the treatment of conditions that affect mobility. So you're subject to that higher requirement. So think weight scales. You may have 20 weight scales across various locations in your facility. As you're replacing those weight scales after beginning this summer on July 8th, the next two weight scales you purchase will need to meet the MDE requirements, because that will then bring you into compliance with the 10% standard. The third one that you're replacing would not have to meet the MDE standards. But of course, if you're increasing the number of weight scales you have, you need to make sure you're doing so in a manner that keeps you within that 10% requirement. The further requirement imposed by these regulations specific to exam tables and weight scales is that by July 8th of 2026, so about 2 years from now, at least one unit must be accessible. So before July 8th of 2026, it's a matter of replacement. If you replace, you must bring yourselves into compliance with the scoping requirements. But then by July 8th of 2006, if it's an exam table or a weight scale, you're going to need to have at least one unit of each. If you are a hospital or a large clinic, operating in multiple locations, you need to disperse accessible MDE proportionately to all departments, clinics, or specialties using MDE. So you can't effectively have all the MDE accessible weight scales in the ER, right? Have them all lined up and that meets your 10% requirement. Instead, you'll have to have them dispersed to physician clinics or other locations where that MDE would be utilized. In addition to these acquisition obligations. You also need to make sure that your staff is appropriately trained on the use of accessible MDE. So if you have an exam table that lowers so that a person in a wheelchair can utilize it, you need to make sure that nursing staff is able to use that exam table appropriately. But in addition to these acquisition requirements, there is still the requirement that you have to provide care in a non-discriminatory manner. And that includes your ability to deliver services to individuals with disabilities utilizing appropriate diagnostic equipment. So yes, you have the requirement to acquire equipment that complies with the MD standards, but you also have a requirement that's effective on July 8th of this year that you cannot deny services due to a lack of accessible MDE. So this is imposing a broader obligation that in these circumstances arrange to have services provided elsewhere or to provide a home visit, otherwise making an appropriate accommodation in those circumstances. But a flat out denial of services based on the lack of available equipment would be a violation then of these new Section 504 requirements. Other provisions of the Section 504 rule, because remember it's a disability-driven rule, but it's not just limited to medical diagnostic equipment. And just to summarize, these other obligations now applicable to providers prohibiting discrimination based on a disability. A very broad prohibition on denying or limiting clinically appropriate care to an individual with a disability due to a bias or stereotype concerning disabled individuals, a belief that such individuals place a burden on others, or the belief that the life of an individual with disability has a lesser value. It's a very interesting read in the final rule, the types of discrimination that were brought to the attention of OCR as they were developing this rule, such as keeping an individual with a disability off a heart transplant list based on the assumption that they would not be able to appropriately follow post-transplant treatment, or denying care to an individual with substance use disorder because they wouldn't be able to comply with the treatment regimen. It's that bias that's the critical element. If it's an individualized determination based on an evaluation of the patient, that's permitted to this rule, but it's that broader excuse me, limitation of a person's access to care just based on the fact they have a disability. Additionally, 504 is going to require your web content as well as your mobile apps comply with certain accessibility standards. And the specific requirements there on your slide for you. There are specific exemptions on types of web content that does not have to be updated. But here are the requirements. You have some leeway time to bring yourself into compliance. May 11th of 2006 for those with more than 15 employees. You get an extra year if you have fewer than 15 employees. Note also that the standard that's created by the regulation is actually not the current standard in use. The present industry standard is actually one level up. But as you are considering updating your website, updating any mobile app that you utilize, makes a lot of sense to have a conversation with the website developer to ensure that you're meeting these web content accessibility guidelines so that individuals are not limited in accessing care for those ways. Similarly, a requirement that individuals with disabilities cannot be denied benefits furnished through self-service kiosks. So if you're using kiosks for patient check-in, you'll have to have an accommodation for individuals who cannot use those self-service kiosks and apply that alternative in a manner that does not discriminate. For example, if you're using a self-service kiosk and you opt to instead talk to a real person, some kiosks will cancel your appointment for you and require you to reschedule with the individual. You can't do that any longer. You have to ensure that it's being provided in a fair and accurate way. So again, new requirements under 504, broader than just those MDE requirements. Probably not as directly impactful right out of the gate as MDE requirements are going to be, but certainly make sure these are on your radar screen. So, so that's what OCR has for us. We have across HIPAA and the anti-discrimination provisions. Let's talk very briefly about our upcoming regulatory roundups. On October 23, Sarah Bowman is going to do a deep dive into 340B updates that you need to know. On November 13, it is our intention to talk about the OPPS final rule, assuming that the outpatient rule is published by November 13th. And then again, assuming that the Medicare physician fee schedule rule is published, we plan to cover that across 3 webinars, November 20th, December 4th, and 11th. So you may want to mark those on your calendar. So thanks for joining us today. And so Trevor, back to you.
Thank you for listening to this PYA webinar recast. The video recording, slides, and associated material for this and all PYA webinars are available on our website. If you have any questions or if we can help, please contact us at pyapc.com. Thank you again for joining us and have a great rest of your day.